Question is that the bill be now read the second time. Mr. Murali, Pillai.
Mr. Speaker, sir, it is important to bear in mind that the aim of this bill is relatively narrow and coheres with the current policy underpinning the relevant articles in the Constitution. In the main, it serves to update the disqualification criteria concerning criminal convictions for membership for Parliament as set out in Article 45 of the Constitution. In this regard, what is proposed, as mentioned by the Honourable Minister, is to revise the fine quantum from not less than 2,000 to not less than 10,000. As a consequence, it is proposed that the disqualification criteria for a member of a Council of Presidential Advisors and Presidential Council of Monetary Rights, as well as a candidate standing for elections as a president, be similarly updated. As stated by the Elections Department in its press release, the proposed revision is to account for inflation over the years. The Honourable Minister said 2000 in the year of independence is about $8,000 now, and ensure that the quantum is commensurate with fines meted out for offences that are relevant to the integrity of the person. In light of this background, unless an honourable member wishes to advocate a change in the current policy, which has been in place since independence, the proposed light touch amendment to the Constitution should not raise controversy. It may be useful to appreciate the underpinning of this policy. It is connected to the concept of universal suffrage, the right to vote for a candidate of his or her choice. John Stuart Mill, a well-known English philosopher, stated as follows in his 1861 essay, Representative Government. There ought to be no pariahs in a full-grown and civilized nation, no persons disqualified except through their own default. Emeritus Professor Joseph Giaconelli, in his 2020 article entitled Constitutional Disqualification, stated that whilst Mill was addressing the question of the extent of the right to vote, the same point applies to the right to stand for office. He went on to state, and I quote, "It applies with greater force, since to provide otherwise would be to limit the range of choices available to the electorate," unquote. In other words, our approach is to leave decisions on the electability of a candidate to an informed electorate unless the candidate has committed a serious offence which attracts a sentence of more than 1 year, or as proposed in this bill, a fine of more than $10,000. Even then, the automatic disqualification ceases after a 5-year period, as provided for under Article 45(2) of the Constitution. The approach in UK and other countries is similar. Under UK's Representation of People's Act, a person will be ineligible to stand for elections if he has been convicted of a criminal offence and sentenced to imprisonment of 1 year or more. For these reasons, I support the bill. It is fair that the electorate is presented with the widest possible slate of candidates compatible with a minimum level of checks for the integrity of the person. It's also fair that the candidate's previous disqualification be reset after a certain period. This bill, however, relates not only to disqualification to enter into an election. It also has an impact on the qualification to remain as an MP. Currently, by default, both issues are tagged in that the same criteria applies to a sitting MP. Hence, notwithstanding my support for the bill, I feel it necessary to signpost for future consideration the ability of an MP to continue in his or her office upon being convicted of a criminal offence whilst in office. Just last month, The Guardian reported a case of a UK MP in the House of Commons who was convicted of sexually molesting a 15-year-old. He apparently did not resign immediately, although it has now been reported that he has since resigned. We can ask ourselves, what would be the case if this happened in Singapore? I dare say a good number of Singaporeans outside this house would assume that the MP would automatically be disqualified from holding office, as his conduct would have brought disrepute to the House, and quite frankly, our country too. That is not necessarily the case, however, if we were to look at the current provisions. As I mentioned earlier, the disqualification criteria for a candidate is the same as the disqualification criteria of an MP. This is provided for under Article 46 of the Constitution. Hence, Whether or not a sitting MP convicted of a crime will automatically be disqualified would depend on not just his conviction, but his sentence. If the sentence of imprisonment is less than 1 year, then he's not automatically disqualified. I did an informal survey of sentences imposed by the courts in cases reported by the Straits Times between March and April this year. I noted the following cases. A Singaporean male was convicted and sentenced to 1 week jail for possession of obscene videos, including child sexual abuse material. Another Singaporean male who molested a female teenager by touching her soles and toes was sentenced to 2 weeks and 5 days jail. In another case, a Singaporean male was convicted after pleading guilty to 5 counts of forgery for the purpose of cheating, involving $9.7 million. He was sentenced to 9 months jail. If an MP were to have committed any one of these offences, he would not be automatically disqualified. Of course, his tenure ceases automatically if he resigns from his party, or if he loses his whip, which is the parliamentary parlance for being expelled from his political party. This latter ground does not affect independent MPs, though. There's a connected aspect to this issue which I seek to highlight. For professionals such as doctors, lawyers, engineers, they will not be allowed to practice, so long as they are convicted of offences that involve moral turpitude, irrespective of the sentences. Civil servants and uniformed officers convicted of crimes may be dismissed, reduced in rank, or otherwise punished too. It may be helpful for us as a heuristic to think of this as 2 keys. The first, a qualification to enter into the profession, and the second, a qualification to remain. The question that arises for consideration is, what should be the corresponding standard of conduct dealing with criminal convictions imposed on Singaporean politicians? That is, what should be the strength of the second key for MPs? To me, this is a no-brainer. Whenever we MPs enter Parliament, we receive salutes from the uniformed officers on duty. This is meant to be a mark of respect for us as elected representatives of our country. Isn't it anomalous that a saluting officer is held to a higher standard as compared to us? This does not make sense. Therefore, we might want to consider if we want to impose similar requirements on sitting MPs. While this may be a simple enough task for this House to consider these issues, to implement a policy solution would require bipartisan support from both sides of the aisle. Without bipartisan support, there will be a serious potential for misinterpretation of the purpose behind the imposition of high standards for Singaporean politicians. What should be avoided at all costs is a perception that the bill is an attempt on the part of one political party trying to constrain the public's right to vote for a candidate of their choice. Also, both sides of the House will need to come to a consensus on how we should deal with politicians who may be convicted for acts of civil disobedience or conscience, which is markedly different from criminal behavior. Once we have struck a consensus on how to treat criminal convictions of sitting MPs in this House, then I would imagine that the disqualification criteria for candidates and members of other high constitutional offices may have to be reviewed again. Mr. Speaker, sir, to agree on this bill is an easy matter. To my mind, it's a simple updating exercise. This bill does not propose to deal directly with 2 other important matters, the disqualification criteria of sitting MPs and parity of standards between sitting MPs and professional civil servants and uniformed officers. This second key, in my respectful view, appears to be weaker for MPs. These are important matters, but we can debate on this in good time, given that any constitutional amendment here should require strong bipartisan support. I support the bill.